So having a look at Picanona which is that 11th Circuit case that I referred to that I handed up to the court, you'll see on page 3, and there's specific language here that kind of addresses which is where I'm going. And that is, since the Fry decision, tremendous advances have been made in polygraph instrumentation and technique. Better equipment is being used by more adequately trained polygraph administrators. Further, polygraph tests are used extensively by government agencies, field investigative agencies such as the FBI, the Secret Service, military intelligence, and law enforcement agencies use the polygraph. And they go on to say that we believe it is no longer accurate to state categorically that polygraph testing lacks general acceptance for use in all circumstances. So that basically sets the stage for when this court believed that it could be used. And as it specifically relates to this case is the idea of impeachment or corroboration, which is addressed on the 5th page of the opinion. And so it then sets out under certain circumstances as to when it could be used under appropriate conditions.
I mean, but even under this case, which obviously is not binding on the House Court of Appeals, but I mean, it's an interesting issue. It says the second situation which a polygraph exam evidence may be admitted is when it is used to impeach or corroborate the testimony of a witness at trial. Admission of polygraph evidence for these purposes is subject to 3 preliminary conditions. First, the party planning to use the evidence for trial must provide adequate notice to the opposing party that the expert testimony will be offered. If I followed this, that's probably occurred. Second, polygraph expert testimony by a party will be admissible only if the opposing party was given reasonable opportunity to have its own polygraph expert administer a test covering substantially the same questions, which has not occurred. Failure to provide adequate notice or reasonable opportunity for the opposing side to administer its own test as proper grounds for exclusion of the evidence. And finally, whether used to corroborate or impeach the admissibility of the polygraph administrator's testimony will be governed by the federal rules of evidence for admissibility of corroboration or impeachment testimony. But anyway, I'm not saying I'm going to follow this, but even in this situation, it wouldn't be admissible because there wasn't an opportunity. I don't think I'm going to let this in anyway, because I don't think I want to go out on this limb, but I do think if it does come to a point where we would consider this, I think there would need to be a new polygraph exam where both sides were present if the Court of Appeals requires me to do that. I'm not going to allow in a polygraph exam where he wasn't present and he didn't have anyone present. And I mean, that just, and I don't think even this case, which is probably the best case in the country for you, even says that. But anyway, go ahead.
So the point being that there's a recognition at this point that there have been significant strides, Judge. And it goes on to the Posada case, which is the other case, the circuit case, which I provided the court. And in this case, the question again is whether there have been sufficient types of changes. So I'm going to point the court to page 6 of this opinion. And it says there can be no doubt that advances have been made in polygraph instrumentation and technique in the years since Fry. It goes on to say modern instrumentation detects changes in the subject's blood pressure, pulse, thoracic and abdominal respiration, and galvanic skin response. And current research indicates that when given under controlled conditions, the polygraph technique accurately predicts truth or deception between 70 and 90% of the time. And it goes on to say there is good indication that polygraph technique and the requirements for professional polygraphists are becoming progressively more standardized. In addition, polygraph technique has been and continues to be subjected to extensive study and publication. Finally, polygraphy is now widely used by employers and government agencies alike. So, in essence, what the court's saying is that the old idea of just sort of per se inadmissibility is out the window, and that you need to look at it. So again, we're talking about things that happened, this is over 30 years ago. Well, I said over 30 years, it's 29 years ago, but thereabouts. So even in that time, there have been significant advances. And that's what I'm looking for, is that opportunity to be able to present that evidence that meets the various standards for the Robinson factors. Okay, so it's just really the question of being given the opportunity to determine the scientific reliability of polygraph evidence. And they're the various Robinson factors that would be considered by the court on all of these various pieces. And having said that, you know, that's what we'd be looking for here. That these particular factors are all given some sort of answer based on what I have presented to the court. It's just simply what's in provided by the Lee case and by the Posada case, and also by Piccanona, which covers all of the various Robinson factors, and we believe that they're all satisfied. Of significance, I think, in the Lee case, which I gave you, which is the Supreme Court of New Mexico case with 2004 judge, that particular case pretty much tells you how it works. And if you have a look at page 5 of the case that I gave you, I mean, I'm not going to read it to you, but it basically tells you exactly how a polygraph works. And it lays out the...
So you indicate in this quote that says New Mexico codified the admissibility of polygraph evidence and NMR evidence. I'm not sure what that means. New Mexico rule
Judge,
of
there's
evidence.
a statute.
There's a statutory. Do we have the same statute in Texas?
We don't have a statute in Texas. New Mexico, as far as I'm aware, is the only state in the country that has a statute that specifically sets out the conditions for admissibility of a polygraph test. So, you know, to the extent that they do have that, and I believe it was put in effect, you know, 20, 25, 30 years ago. It's been a while. But what I want to point out is really their reliance in the Lee case on the National Academy of Sciences and their research that they did on polygraph and lie detection back in 2003. And from the results of that, this court goes through all of the various steps in the Daubert inquiry and their state law equivalent, and they come to the conclusion that, you know, it should be admissible and it's not a sort of per se exclusion, and that there is a scientific validity. So the other piece that I wanted to point out to the court is something that Mr. Kavari addressed in his reply brief or his response. And that is this idea that jurors are simply going to go ahead and accept the, you know, the determination from the test, and that they're just going to go ahead and give it that credibility. And I believe that that's taken from a statement that was made in one of the cases that Mr. Kavari cites. However, there are studies that show exactly the opposite, and those are part of footnote 14 in the Piccanona case. So there are some studies that go ahead and refute that idea that jurors are going to likely give disproportionate weight to polygraph evidence. And why this is important is because obviously, Judge, we know in a case like this, which is a he said, she said type situation, credibility is in the province of the jury here. They're the ones that are going to make that determination. And they get to go ahead and determine what weight to give testimony of the various witnesses, and also this. It's not something that just definitively is taken as, yep, this is exactly the way it is. And the remedy that Mr. Kavari would have here is cross-examination or some kind of, you know, rebuttal evidence. That's what is available to somebody to go ahead and attack a test result here. So with that, Judge,
We have only a few minutes left. Are you guys here for the 10:05 hearing? Okay, so let's let Mr. Kavari have a few words before we end the hearing. So
may I proceed, Your Honor?
yeah, you may.
Your Honor, I'm not going to go into the background of the case. We've already kind of covered that. Mr. Whiting has in detail. As the court has already noticed, this polygraph was taken and completed without plaintiff's involvement or involvement of plaintiff's counsel. And as stated by Mr. Whiting, the purpose of the polygraph exam is that he's seeking admission is to prove that Dr. DeMaio's statements were truthful with respect to intent. And I'm going to jump quickly, since we just only have a few minutes, to matter of JG, which I think hits home with this intent issue. And in that case, JG testified that inappropriate touching of young girls was accidental, which is what he had been accused of. JG relied on results of an ABLE assessment, which the court found was similar to polygraph, to demonstrate that he was not sexually aroused by young girls. In that case, the Austin Court of Appeals held that an ABLE assessment, much like the results of a polygraph, are per se inadmissible because the results of the ABLE assessment would have confirmed JG's testimony, which is what Mr. Whiting is seeking from admissibility of the polygraph exam here, essentially bolstering his testimony and demonstrating that he was telling the truth about his lack of intent. That's all we're focused on here. This polygraph and the two questions that were asked were centered and focused on intent. So if this polygraph exam comes in that bolsters Dr. DeMaio's statements with regards to his intent, what is the jury going to do with that evidence? It's coming from an expert witness. It's going to bolster his testimony. It's going to increase the likelihood that the jury will find his statements to be truthful. And it's going straight to the heart of intent, which the Austin Court of Appeals said no. I've already kind of provided the deposition testimony transcripts. Dr. DeMaio vehemently denied ever touching Ms. Husak. He actually didn't even remember if Ms. Husak was in the room or not. Now we're seeking admission of these statements for the purpose of establishing that intent was not present. I've made arguments about the lack of safeguards being present, which the court has already kind of taken notice of, so I'm not going to go into that. So for that reason, Your Honor, we'd ask that the polygraph exam be determined to be inadmissible and relief sought by Dr. DeMaio be denied.
All right. So, as a trial judge, I have kind of a particular role here, which is it's not for me to make the law. It's for the Court of Appeals, legislature. The law in Texas state court at this point is that these are kind of not admissible under any circumstance. And so if the Court of Appeals or Supreme Court says there should be a Daubert hearing, I have no problem with that. Personally, I have a concern that if we start doing this, just me as a trial judge, you start doing this, you could have so many of our cases come down to he said, she said, or he said, or she said, she said, and you could see just a complete explosion of the number of cases where polygraphs and this type of procedure could come into play. This case is really not unique, in my opinion, when it comes to that issue. And so I don't feel as a trial judge, it's my role in a situation like this to change the law. The legislature wants to do it. Courts of Appeals want to do it. Say I have to do. I think if we do it, what the next step would be if the Court of Appeals comes back, my thought would be the next step was we need to do a Daubert hearing. I don't foresee that I would unless I'm directly ordered by the Court of Appeals, you must allow this in, which that isn't even what this other case says. I think there would need to probably be a new polygraph exam with both sides present. I just think that increases the cost of litigation, not necessary, and I question the science. But so I don't know if that helps at all, but that's my thoughts on it. But I'm going to deny the request. All right. And you probably expected that, but but good argument, very interesting, and you guys have a great rest of your day. Okay.
Thank you, Judge.
Thank you, Your Honor.
Hey, when are you guys set for trial?
I think it's
May.
May.
May or August? I'm gonna say.
I think it's May, Judge.
Okay.
May 20th, 21st? May 20th?
Okay. We're reaching pretty much every trial at this point, so no matter where you are on the docket, most weeks we're reaching everybody. So, so you're especially set, so
Yep.
it's not even an issue. So
Much better to have the case with you, Judge.
I agree. All right. You guys have a great rest of your day.
Thank you, Your Honor.
You guys set up the next case. I'll be right back.
You guys with some novel arguments? There's some novel arguments.
Yeah, it was interesting. I always love, getting here early for hearings. Just totally different stuff I'm working on,
Yeah, I don't think this is every day for him.
So,
Well, sometimes you gotta take the shot. See where it goes.
yeah, no, that's interesting stuff.
Yeah.
Well presented.
I think.
Oh, yeah. Well, on any, like all Americans, I'm a sucker for British or whatever it was,
Sure.
that I may or may not use.
Ah. Okay, guys, is everyone here that needs to be here? It's not quite 10:05 yet.
I believe so, Your Honor.
I believe so, Your Honor.
All right, let me get started here. All right, let's go on the record on cause number DC 23-17198, Husak versus Baylor, Scott and White Health. Counsel, make your, I'm sorry, wrong case. Let's go on the record on DC 23-18308, Texas Young Republican Federation versus Ashley Leathers et al. Counsel, make your appearance.
Connor Ellington and Tony McDonald on behalf of defendants Heath Bell and Young Republicans of Texas.
James Ringel on behalf of plaintiff.
All right. You may proceed.
So, good morning, Your Honor. We have two TCPA motions before the court today. We're happy to present whatever way the court would like, but my thoughts are that we start with Bell's TCPA motion, and then we allow for opposing counsel to present, and then move on to YRT's TCPA motion, and then allow opposing counsel to present.
Let's just do them all at once.
Okay, sure. So to begin with Bell's, defendant Heath Bell's TCPA motion to dismiss. TYRF, Texas Young Republicans Federation, the plaintiff in this case, has non-suited the two trademark causes of action against Bell. And only the breach of fiduciary duty cause of action remains against him. So as to the
So let me, I read the briefing. It wasn't super clear to me. So what was Bell's position with the TRF?
He's going to be the vice chairman.
He was the vice chairman at the time.
Or, no, sorry, not as to TYRF, as to he was the social media manager, I think, for TYRF or something like that.
Was he on the board?
The EC, the executive council.
Executive, he was on the executive committee of the Texas of the Federation. We'll just say the Federation of the Federation. He was on the executive committee of the Federation.
That's correct.
Okay. So the first question I had, and it wasn't super clear in the briefing to me, are there any cases that have applied the TCPA to a breach of fiduciary duty case?
Not to my, I don't believe so, Your Honor.
Okay. All right. And are there any Dallas Court of Appeals cases? What exactly, when he made these statements, it was a little unclear to me, when he made these statements about, I think he said something like, what did he say? That somebody with TRF was going to drag them through the gutters of the judicial system or something like that. Is that kind of what he said, what he allegedly shared, I guess,
yeah.
that statement. What was TRF status? Was it a corporation? Was it what was their legal status at that moment that the statements were made?
So,
or that not the statements were made, that let me make it clear what I'm asking, because that wasn't very clear. At the moment that he released these, I guess, screenshots, is that what they were, screenshots?
yes, Your Honor.
What was the status of TRF? What entity were they? Legal entity were they?
So that would be a question to ask them, because they claim they're an unincorporated nonprofit association.
Okay.
Whereas whenever they originally brought the lawsuit, they claimed that they were a nonprofit corporation.
Okay. So go ahead.
But there's also the timeline as to when the lawsuit was brought, which was October 23rd, 2023. And whenever Heath Bell had his declaration that was attached to then Chad Cohen's TCPA motion to dismiss, which that is dated November 13th, 2023. So these statements are being made after the legal proceeding, or they're being shared with the court after the legal proceeding against Heath Bell had already been made.
Say that again.
Sure. So the timeline of when these screenshots are shared is that the Federation sues Heath Bell. Heath Bell then shares these screenshots with his co-defendants in this case, and it's brought to this court's attention.
He shared it just with the co-defendants, not with anyone else?
That's correct, Your Honor.
I thought he put it on social media. No, I misunderstood. Okay, so all he did was share it with the co-defendants?
Who then, it was attached to his co-defendants' TCPA motion to dismiss.
Okay. Because to me, I guess part of the question is the TCPA, I have serious issues with this whole lawsuit for a variety of reasons, just because of and the briefing on the other side is not super clear to me. But the question I guess I have in my mind is the TCPA the right way to deal with this particular issue? And then the second issue I have is what exactly was Heath Bell's role in all of this? Like what he was the vice chair of an unincorporated association. So there was kind of contrary briefing, assuming that they're correct, and this was an unincorporated unincorporated association, nonprofit. What case law is there to indicate that there is a fiduciary duty for somebody who's on an executive committee in that situation? Is there a case? I kind of think there was case law in both directions.
The only case law that exists is out of the Austin Court of Appeals. That's going to be the Garst case. And let's see here, it's the Garst case, and I believe it's the Port of Call Homeowners Association, and both of those suggest that there's no fiduciary duty that exists. So the Texas legislature, for the Nonprofit Corporations Act, very clearly lays out a fiduciary duty existing in the relation of there being a corporation, whereas with the with unincorporated associations, the Texas legislature very well could have done that, but it hasn't. So
can I see a copy of those cases?
I don't believe I don't have a printed copy of.
Do you have a printed copy?
I do not have a printed copy.
You have
of
a
the
printed
case.
copy?
I have the excerpts that I've cited too. I don't have the whole case law, Your Honor.
Okay.
I do have the I do have the citations to those cases though. That would be used to the court.
Okay.
Obviously, we can get copies of the cases to the court this afternoon if you'd like.
Okay. All right. Go ahead.
Sure. So so the TCPA is going to be the proper vehicle upon which.
Do you agree that that's the correct statement of the law? And I don't want you to do extra work if he agrees that that's the correct statement of the law, that there is no fiduciary duty in that situation.
No, Your Honor, we disagree on that point.
What case law do you have supporting your position?
So there is no case law exactly on point in either direction. We sort of make an argument in reading the statutes as well as the revised uniform unincorporated nonprofit association.
Because you don't do anything in your briefing to distinguish these cases. So go ahead and distinguish them to me now.
Yes, Your Honor. The two primary cases that defendants cite to, as Mr. Ellington noted, were Garst v. Reagan and Green versus Port of Call. In those cases, the Austin Court of Appeals and those specifically said that those were related to homeowners associations. And the holding in those cases and the statements in those cases were that a member of the board of an unincorporated nonprofit association, in those cases an HOA, did not have a fiduciary duty to individual property owners. It says nothing about whether or not there's a fiduciary duty to the association itself, the organization itself.
So it says there is fiduciary duty, or they just doesn't address it?
It just doesn't address it in either case.
Okay. All right, go ahead.
So it's important to emphasize that
Do you agree with that? Do you agree that that's not addressed?
I mean, the general proposition those cases stand for is that if you have an unincorporated association, that absent a showing of something else, there is no fiduciary duty.
Absent a showing of something else, what do you mean?
Yeah, there has to be something else that establishes it. So for instance, if you have a nonprofit corporation, you would point to the statute that clearly delineates, the Texas legislature passed, that clearly delineates that for nonprofit corporations, directors owe fiduciary duties to the organization. But it is important to emphasize that our burden here is to establish, our burden at TCPA step 1 is to establish that the act applies. In the event that it applies, the burden then shifts to them to provide a prima facie case via clear and specific evidence for each essential element of their causes of action. So once we establish the TCPA applies here, the burden is then on them.
But don't you agree that in a situation, let's assume that your client did have fiduciary duty, just like you have fiduciary duty to your client, right? You have the right to freedom of speech, correct?
That's correct, Your Honor.
But that doesn't mean if your client conveys something to you in confidence that you still have the right to share that information, correct?
That's correct.
So in some sense, the fact that you have a fiduciary duty with your client impacts your First Amendment rights, correct?
That's correct, Your Honor.
So if a fiduciary duty, I'm gonna say it does, exists in this case, then that would have restricted that, the existence of that duty would restrict Mr. Bell's ability to exercise his First Amendment rights, correct?
That's incorrect, and for two reasons.
Why is that?
So to begin with, at the point that they complain of, the fiduciary relationship does not exist. So the reason why I mentioned that the first time that these messages end up showing up before the court are on November 3rd, 2023. This is after they have sued Bell. Like, these communications are only being made public once Bell has been sued in this lawsuit. This is a part of his legal defense. So for instance, whereas while normally with an attorney-client relationship, there is a confidentiality there, those rules do not fully apply whenever, say, a client sues an attorney and then the dispute ends up being Does that make any sense? Is that?
No, I there's a particular provision about that, but generally I've handled a lot of fiduciary duty litigation. Just because you've been sued and you're a fiduciary doesn't mean that you have the right to then share any information you learned during that fiduciary relationship. I agree with you. I'm not sure there is a fiduciary relationship here. Right. I'm just saying if there is a fiduciary relationship, it's not as clear. You're right. There may be an issue because he'd already been sued. And then also there may be, I'm not 100% clear who exactly he shared this with, but he could potentially have a joint defense privilege to share information like that. Still, I mean, okay, it gets a little more complicated. Who the people he shared it with, were they also board members of the TRF?
This is going to be for Young Republicans of Texas. The defendant. No.
No. Okay. Sorry, I got you off your game. What were you going to say?
Yeah, it's but essentially if you have questions or like, well, it's not clear what this or that has any bearing on this, that's on them to prove in their prima facie case. Is that so? If you have these questions, then you would then say, well, the breach of fiduciary duty cause of action needs to be dismissed against Bell under TCPA Step 2 because they haven't shown their prima facie case. So in relation to the two non-suited causes of action against Bell, so whenever they still had their third amended petition, they had the two causes of action that they had pled against Chad Cohen, which were dismissed up at the Dallas Court of Appeals. That's going to be the trademark infringement and the trademark dilution causes of action. So after Bell files his TCPA motion, they non-suit those claims against him. And we have the Texas Courts of Appeals say that whenever you non-suit after a TCPA motion has been filed, it doesn't. So we have a Dallas Court of Appeals case. It's Du Coquette that stands for the proposition that if you say, well, that's not involved in the case anymore, this is moot now because the causes of action have been dropped. That's not the case for a TCPA motion to dismiss because it's an affirmative request for relief, because whereas a non-suit would be dismissal without prejudice, dismissal under the TCPA motion, the TCPA motion to dismiss is dismissal with prejudice. And then there's also attorney's fees requested and potentially sanctioned. So that doesn't moot those two causes of action they pled against Bell. But also because they have non-suited them, those claims fail under TCPA Step 2 because they don't even put up a prima facie case for them. And those cases are going to be, that's Craig v. Tejas Promotions, LLC. That's out of Austin in 2018. Holding that a trial court had no discretion but to grant a TCPA motion when the act applied and the plaintiff non-suited its claim, arguing that the claim was no longer a part of the case. Then we also have TNCPA PC v. Wynn, and that's going to be out of the Houston 14th District Court of Appeals, and that's in 2020. And it says that non-suiting a claim fails TCPA Step 2, warranting dismissal of the claim under the TCPA.
Can you say that?
Sure. Where would you like me to begin?
Second one.
Okay, second case. Yeah, so sorry, it's a bunch of acronyms in particular there, and that's why I had to write it down. So it's TN space CPA, comma, P period C period, and that's V win, like the NGUYEN. Yeah.
Okay. Do you have
So
anything else?
as to so there's also the TCPA step 3, but I can also return to that with YRT's motion to dismiss because those are very similar arguments there.
Okay, go ahead.
All right. So would you like me to go to YRT's TCPA
Sure.
motion? Okay. So we winding the clock back, we then have the 3-step TCPA process here. The Federation has 2 causes of action against YRT, and that's going to be common law trademark infringement and trademark dilution. So to begin with, the TCPA applies here. They generally don't contest that it applies, but they make the same argument that they made to this court in relation to the Cohen TCPA motion to dismiss that this court disagreed with, and the Dallas Court of Appeals also disagreed with, that the commercial speech exemption applies. So as the Supreme Court of Texas makes clear in the Castleman case, for the commercial speech exemption to apply, there are essentially 4 elements. The defendant must be primarily engaged in the business of selling or leasing goods or services. The second element is that the defendant made the statement or engaged in the conduct on which the claim is based in the defendant's capacity as a seller or lessor of those goods or services. 3, the statement or conduct at issue arose out of a commercial transaction involving the kinds of goods or services that the defendant provides. And 4, that the intended audience of the statement or conduct were actual or potential customers of the defendant for the kinds of goods or services that the defendant provides. So to begin with, there is no evidence of any commercial speech here. They point to 2 things. They point to YRT's donation page on their website. So the donation page says, we're not accepting donations now at the moment, but if you give us your contact information, we might in the future take donations and we'll reach out to you. And then they also point to what purports to be a photograph of a booth of YRTs at some event, and there's a little placard at the bottom that says donate to YRT, and there's a QR code. That's all the information that they've provided. So as to whether or not YRT is accepting donations, it's not clear.
As this is slightly different than the Cohen case, I think, but are there any cases that apply the commercial speech one way or the other exemption to nonprofits?
There might be, but it's different than here. If so, I don't know of any off the top of my head, but
do you know of any?
None specifically to the TCPA. We referenced to the Lanham Act in our brief, which is sort of the federal trademark, similar to the trademark claims we've established. And there they do apply to nonprofits doing charitable work, et cetera.
But it's important to note that the Lanham Act, in its use of commercial language, and this is something that we get into in relation to the United We Stand case that they cite to, is that whenever the Lanham Act is using the term commercial, what they're talking about there is the Federal Commerce Clause power, and that it was Congress's intent to map onto the Federal Commerce Clause power, of course, being the federal government being one of limited enumerated powers, one con law class here, that is fundamentally a separate and discrete area of law in relation to the commercial speech exemption. Because if you look at the text of the commercial speech exemption, it is not about mapping onto the Federal Commerce Clause power. It's about separating commercial speech from non-commercial speech, because commercial speech hits on different interests than non-commercial speech, in particular here of political speech, of political clubs, of people organizing and associating to promote policy and candidates that they support. And there actually is, even within the Lanham Act context, there are 2 cases of particular interest to this court on that point. We've got the Nader v. MasterCard case that we cite too, which is out.
Did you
of-
spell Nader?
Yeah, so that's Nader. Yeah, not like Nadir or Nadir. It's the Nader v. MasterCard case, which is out of the Southern District of New York. And then we also have the American Family Life Insurance Company v. Hagan, which is out of District Court in
Just for the
Ohio.
corporate, how do you spell Hagan?
Sure. That is Hagan.
Okay.
My apologies. Some of that's a little bit difficult to follow. My drawl comes out a little bit when I'm excited. But essentially, what those two cases stand for is that proposition that the stuff that they're complaining of here is wholly non-commercial political speech and activity. So, and aside from this, the only thing that the Federation complains of here is that they suppose, well, young Republicans of Texas are probably, they suppose, they don't say, well, they are engaged in this, they just suppose, well, young Republicans of Texas is probably going to block walk, and that's a service. Well, fundamentally, no, there's a difference between, there are people that I agree with, and we're all together, and we say, those candidates have values that we support, and as such, we're going to volunteer, and we're going to go block walk for them.
Well, let me throw out a hypothetical here. So have you ever heard of Antifa?
Unfortunately, yes.
Okay, so imagine a group of Antifa, I don't know what, volunteers, decides to form a group called the Young Republicans of Texas.
Sure.
And they start marketing to Republicans as the Young Republicans of Texas. That's the name of your group, right? Would the and you sue them and say, hey, look, you're violating our trademark. I feel like under your argument, they have the right to go forward with that, even though it's exactly the same name and it's exactly even though they don't hold, I imagine, any of the same values that you guys do. I'm trying to pick an example that's as different as possible. Would they be violating your trademark?
So a couple of things on that particular hypothetical that come to mind. First of all, that's disanalogous from the situation that we're in right now, because first of all, they claim a trademark to the term young Republicans. So if we were to make this one-to-one in relation to this situation, it would be something like if they claim to be an organization like Young Republicans of Austin or something like that.
Well, let's say the Lone Star Young Republicans. That
Right.
the Lone Star.
We wouldn't say that there's any trademark infringement there because the term Young Republicans is generic. And then,
Okay.
then the point would be to publicize, hey, you have these bad actors here that are, Antifa members that are purporting to do this and so on and so forth. But I don't think that a trademark infringement lawsuit is particularly fruitful in that sense, because particularly if they're Antifa members, there's probably not going to be any financial incentive to
Let's say they're backed by George Soros. I don't know if there's any relationship between. I'm just throwing out. I mean, there's a group of rich Antifa members who do this, and so I mean, do you see what the issue is? Is that there are situations where I could see. I mean, you guys are. I don't think anyone is questioning that both of these groups are Republican groups, and that's. I mean, I don't think. Maybe they're not real Republicans. Well, you're not real Republicans, but you're both Republican groups. But do you see the issue where people could come in and who are not holding any of your values, in fact, the opposite of that, where they could really dilute your trademark?
I don't think there's a trademark for the term Young Republicans, though, fundamentally.
So if the Antifa, well-funded Antifa group forms the Lone Star, the Young Republicans for Freedom, Lone Star chapter, you feel like they would not be violating any type of trademark of your group?
The term Young Republicans is generic, yeah.
It's generic, okay. But if they call themselves the Young Republicans of Texas, you do think that they would be violating your trademark?
There might be an issue there.
Or what about if they were the Young Republican Federation, Texas Young Republican, but that's what your group is called, Texas Young Republican.
Yeah, if they're purporting to have the exact same name as them,
Same
there
name.
might be an issue there, but that's not what's at issue in this case.
Okay.
So, sorry, working my way back here. So,
Let me ask you this. Do you agree with him on that? Do you think that that's correct? That if this Antifa group comes and forms the Young Republicans Lone Star and they start campaigning for, I don't know who you guys like the least, but Nancy Pelosi for president, I don't know, that would be in violation of any type of trademark of either of your groups?
Your Honor, we assert that Young Republicans within the state of Texas is a trademarkable phrase. It's a descriptive phrase, not a generic one. To briefly sort of address that point, I mean, the U.S. Patent and Trademark Office has granted similar trademark names. For example, the Miami Young Republicans. The U.S. Patent and Trademark Office said Miami Young Republicans is not generic. You can trademark it. The U.S. Patent and Trademark Office even suggests, actually states on their website that a term such as creamy yogurt is descriptive enough to be trademarked if you acquired secondary meaning. We're alleging, and I think the affidavits support that the Federation has obtained a secondary meaning on the term Young Republicans within the state of Texas, as well as the other exhibits that show when people talk about Young Republicans as an organization, not someone who just says, you know, I'm a young person who's a Republican. But when you're talking about a group, Young Republicans, they're talking about the Federation group.
So let me ask you this, because this is really probably the biggest issue in my mind about this whole motion is the Court of Appeals had a ruling involving Mr. Cohen. How do you distinguish? How do you get around that ruling?
Your Honor, the major distinction is that from my recollection of the Court of Appeals opinion, the primary foundation of their ruling in dismissing the case against Cohen was that there was no specific evidence that Cohen himself infringed on the trademark. Their organization, YRT, infringed on the trademark. And so we couldn't hold Mr. Cohen liable for the actions of the organization or the association that he was a member of. That was the gist of the ruling, that we couldn't hold Mr. Cohen responsible. It was not that the commercial speech sort of protection or exemption from the TCPA did not apply. It was that there's no evidence of Cohen specifically infringing the trademark himself. All of the allegations essentially go to the association, which is why afterwards we did non-suit the trademark claims against Defendant Bell, because again, we were claiming that the association did all of these things. Defendants Cohen and Bell were originally included primarily because we couldn't confirm the existence of YRT as an unincorporated nonprofit. That's since been resolved, which is why we dropped the trademark claims against Defendant Bell. And so the Dallas Court of Appeals opinion doesn't quite apply to the claims against the association. The foundation is totally separate from the reasoning here.
Go ahead. Do you agree?
No. So to begin with, that summation of the Dallas Court of Appeals opinion wasn't correct. They found that the commercial speech exemption did not apply. They basically said that we're not deciding the trademark issues, but even if we were to find in this particular context, that Cohen still needed to be dismissed from the case. They did not say, well, we're deciding it this way. Well, they infringed on their trademark this way or that way. The Court of Appeals made no finding. So to go back, they brought up the United States Patent and Trademark Office filings. So if this court goes back and looks at the things they point to as claiming as being registered trademarks, the vast majority of those that they point to, and it's even in their attachment to their TCPA reply.
Exhibit 5.
Exhibit 5, that's correct. Most of those were never registered to begin with. So they claim, well, there are 3 that are live in live trademarks, and only 2 of them are. One of them is live and pending. It has not been accepted by the United States my apologies, United States Patent and Trademark Office. And of the 2, none of those in any way suggest that the term young Republican is not generic. Just as if I was to parade before this court a whole bunch of trademarks that include the word tree service, you know, if it's M Street's superb tree service, that doesn't tell me anything about whether the term tree service is generic or descriptive or any of these other sorts of things. So again, they're not claiming a trademark to Texas Young Republican Federation. They're claiming that they get to tell other people whether or not they can call themselves young Republicans in the state of Texas. And fundamentally, this goes back to, this is at the TCPA step 2 point, as to whether or not the term is, the term that they're claiming can be trademark protected, is that that's their only argument, that the term is not generic, is that they point to those filings, but those filings do not demonstrate that the term young Republican in and of itself is not generic. Just as, like, it would be a different story altogether if there was a filing that was accepted with the United States Patent and Trade Office that was for the term young Republican, but there are geographic descriptors on the 2 that they can point to, which is Miami Young Republicans and Orange County Young Republicans. And I would
have there been any cases, and not just involving young Republicans, because it would be the same for young Democrats or college Democrats or college Republicans. I was very involved with the young Democrats, and so we didn't deal with this exact issue, but this dynamic is very familiar to me. Where there has been a litigation over when you can use the young Republican name, because this actually happened in Texas, and the other group, I think, with the UT Democrats, they broke off from the Young Democrats of Texas many years ago, and they changed their name to the University Democrats. I don't know if that was because of a trademark dispute or what, but I remember that happened. Has there been any type of litigation about the issue of whether young Republicans is something that is or young Democrats or anything like that, that terminology alone is trademarkable, I guess?
So, funnily enough, there has been litigation about this, and actually it was, we brought this up, this will be somewhere in the record. In our response to their cease and desist letter, we actually pointed out that this sort of fight has occurred in California previously, in relation to different young Republican groups. And essentially, the resolution was, there was never a legal resolution to it from my recollection. It was essentially that the powers that be basically said, make nice. So, you know, there was a resolution, but not a legal resolution there. But that's the only one that I'm familiar of that I bring to this court's attention. So going
Well, anyway,
back,
I've let you go on a long time. Let me have them respond.
Yes, Your Honor. I guess briefly, we've covered a lot of ground here, so I'm assuming we're looking for kind of a general response.
Well,
Or are we looking
I
for
mean,
specific issues?
so I'm looking at a couple of specific issues. One is, which I think we've already talked about, is whether or not the fiduciary duty exists as to Heath Bell, and you know, kind of talking about that. And then the second issue for the young Republicans is, are there any cases that interpret whether or not young Republicans by itself is trademarkable? And so, but that's, I guess those are my 2 main issues.
Okay, and I can certainly address those, Your Honor. So as far as the breach of fiduciary duty claim, as we sort of note in our brief, I mean, there is within the chapter regarding unincorporated nonprofit associations, there is a section 252.015, which has to deal with sort of the transfer of property of an inactive unincorporated nonprofit association, wherein it specifically states that if the property was left with a fiduciary, such as an officer, I mean, the statute clearly contemplates that officers are fiduciaries of the association. Aside from the revised Uniform Unincorporated Nonprofit Association Act, which we've kind of gone over already, there are other other statutes throughout the Texas law that sort of imply a fiduciary duty, such as the duty to keep books and records of the association by those in charge. We also argue that board members, employees, agents really generally owe a fiduciary duty to their principals. That's a well-settled Texas principle. One such case is Johnson versus Brewer and Pritchard, PC. It was decided by the Texas Supreme Court in 2002, which states that agency is a special relationship that gives rise to a fiduciary duty. Heath Bell, as a member of the executive committee, was an agent of the association. There's a fiduciary duty as the agent to not.
Your opposing counsel seems to indicate that that this duty may have been abrogated or affected by the fact that Mr. Bell had been sued by your client.
At this moment, I'm not aware of any case law that specifically addresses that. However, to use an analogy, as was being discussed earlier with, for example, attorney-client confidentiality. If an attorney is being sued for, let's say, malpractice, and the client is asserting that, you know, I did this because my attorney said to do this, and the attorney's going, whoa, no, I never said that. Here are the emails specifically at issue. In this case, the lawsuit had nothing to do with those messages and communications that were shared by Mr. Bell.
Well, he said, I'm not sure this is correct, but he said that, or maybe my understanding was that he only shared that with his co-defendants. He did not share it to the general public.
So yes and no.
Okay.
It is, at this point, it is our understanding that he shared it directly with his co-defendants. However, it was then provided as a filing to the court, making it a public record. Regardless, whether or not he should have been able to even share it with his co-defendants is a question here. And I argue that even sharing it with his co-defendants was a breach of the fiduciary duty. Again, nothing in those messages was strictly and directly related to the suit at issue. The suit was a trademark dispute. The text messages and screenshots that were saved from the group chat were related to the fact that my client was intending to sue the new organization or the founders of the association. Again, at that time, it was unclear whether or not there was officially an association or organization to sue. The suit had nothing to do with those messages. There was no reason that it should have been shared. Those messages were sent as part of the executive committee's meetings with counsel. So this also implicates attorney-client privilege, which Mr. Bell did not have authority to waive. And so sort of directly, this caused harm to the Federation because now their sort of private meeting messages have now been shared out to the public at large for essentially no legitimate reason by Mr. Bell. This was a violation of the fiduciary duty. As to the trademark and whether or not Young Republican itself can be trademarked, opposing counsel notes that there is no registered trademark for Young Republicans, specifically just Young Republicans. That is correct. If there was a filed trademark, this case would have been a lot simpler. And we would have asserted statutory claims for that instead of sort of common law trademark claims. However, there is a case regarding libertarian, whether or not libertarian can be trademarked. And that was decided very recently. It was in, just this year, actually, by the U.S. Supreme Court, or sorry, not the U.S. Supreme Court, by a federal court, again, sort of determining whether or not a phrase like libertarian can be trademarked. And the court essentially said, yes. And in fact, we can reach into political actions and political parties' actions to protect trademarks. Just claiming it's political activity doesn't get you out of it. Now, of course, in that case, again, we're talking about the Lanham Act, which is the federal statute. There is no specific case on point as to Texas trademarks on this issue. It just hasn't really been litigated. But the federal cases all essentially say that whether you're a non-
Did you cite within your briefing this case involving the libertarians?
Yes, Your Honor.
Okay.
Just because you're claiming political speech.
Do you have a copy of that case with you?
I may have the excerpt, but I could certainly email to the court the whole case.
So let me do this, because I think this is a close call. What I want you to do, can you guys get along okay to do this together? I hope you can. You seem to be getting along better this time. If you could bring me 2 notebooks, one that has all of the briefing and all of the case law involving the Heath Bell motion, and just one notebook with both sides stuff and all of the cases work together to highlight whatever needs. You can both highlight it, whatever. And then a different one for the young Republicans of Texas, or however you want to call it, TCPA, with both sides again with case law, and you don't need to include the briefing with the attachments. Yeah, include the briefing with the attachments. So 2 different notebooks, different binders. Can you get that to me by Monday?
I believe so, Your Honor.
Do you feel like you can, or Tuesday? Would Tuesday be better? I don't want to.
Tuesday would be good. We're going to be in court on Wednesday.
Okay. Why don't you get it delivered here? Can you get it delivered here first thing in the morning on Tuesday?
Sure.
Yes,
Okay.
Your Honor.
All right. And then I'll try. And what is my deadline to decide this?
30 days. 30 days from today, Your Honor.
30 days from today. Okay. All righty. Well, good argument on both sides. And I'll try to get you a decision as soon as possible. And you guys have any questions?
Not
No,
for me,
Your
Your Honor.
No, Your Honor.
All right. You guys have a great rest of your day. Okay.
Thank you, Your Honor.